Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I am your host, Maryland attorney Elsa W. Smith, and the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Um, it is good to be back, you all. I have been traveling abroad for a couple of weeks, celebrating my wedding anniversary and taking some time to recharge, quite frankly. Um, Switzerland was absolutely beautiful and almost magical, like you're walking through fairy tales that we may have read about when we were children. But as amazing as that whole experience was, it's always nice to come home. And I want to give a shout out to my team members at the firm for keeping everything running while I was away. Shout out you guys who are watching. It truly takes teamwork to make the dream work. I do hope that you enjoyed our fall health and wealth series, where we featured some amazing experts in the fields of mental health and finance. If you missed any of the four episodes in the health and wealth series, I would encourage you to go to our YouTube channel at Elsa W. Smith Law and check them out. And by the way, be sure to subscribe while you're there. This month is National Estate Planning Awareness Month. And as I thought about what I wanted to talk about today, excuse me, I am recovering from a little bit of a cold. So, as I said, as I was thinking about what I wanted to talk about today, I put myself in the shoes of many of the people who call our office. So I thought it would be good to talk about the initial intake process and why we have it. And so we're going to do that first. And then we're going to talk about what you should expect during the estate planning consultations. So, for those of you taking notes, this is the topic for today, the intake process and what you can expect from the estate planning consultation. The hope is to really demystify the whole process so that you're informed and, quite frankly, comfortable when you do contact an estate planning attorney to get your affairs in order. So, with that said, let's get started. We're first going to talk about the intake process. Okay. Now, when you contact most estate planning firms, one of the first things they'll have you do is complete what's called an intake questionnaire or form. So your question is, well, why do I have to complete it? Can I just tell you what I want over the phone and let that be it? An estate planning intake form or a questionnaire, depending on how it's called, is designed to prepare you and alleviate the stress associated with that first meeting. And so, whether you were referred to us by an existing client, another professional, or simply, Googled us and found us online, the hardest part is getting started, getting all that information on paper, if you will, or in our case, on the form digitally. So the intake form helps us to document important details about you before you meet with the attorney. And the form allows us, at a glance to see if we are going to be able to accommodate your needs. It also provides us with essential information about your matter, your case, and then decide what the next steps should be. Um, the information that you provide is going to help us evaluate your specific needs. As I say over and over again, estate planning is not a cookie cutter process. Everyone's situation is different. And You being candid and forthright in that estate planning questionnaire is going to really give us the tools that we need to create a comprehensive estate plan that's going to meet your goals. Now, what's some of the information that we ask for on this, excuse me, on this estate planning intake form? Um, in many cases, in most cases, it's going to start off by asking you about your family, the makeup of your family, um, names, full names, contact information, ages, and perhaps social security numbers. Um, we're also going to ask you about your finances. Do you have stocks, bonds, bank accounts, and other investments? If so, uh, to the best of your ability, give a ballpark figure of what each of those is worth at present. We'll also ask you about retirement accounts, and that includes individual retirement accounts or IRAs, Roth accounts, any profit sharing or pension plans. We'll also ask you about life insurance policies, the type of policies, the name of the carrier, what the face value is of that particular policy. And we'll also ask you about personal property. And with that, automobiles, jewelry, antiques, things of that nature. Um, all that is important, all that, and believe me, there's a purpose for all of that, for all the questions. We're not just asking for the sake of being nosy. There's a reason for all of that. Um, One of the, I would say, the most difficult parts for most people in the estate planning intake form comes in the personal decisions, the decision making questions that we ask of you. They include, who do you want to be the person that's going to administer your estate? And when that's just a fancy way of saying when you die, who's going to be the person in charge of distributing assets according to your will? And hopefully you would have a will. But who is that point person, right? Who do you want to serve as your power of attorney? Now, when we talk about power of attorney, we're talking about, while you're alive, because a power of attorney document is only effective while you're alive. Um, Another question is, who do you want appointed as a legal guardian for your children? If you have minor children, or if you have um, individuals with, say, special needs that still rely on you, if something were to happen to you, who do you want to serve as a legal guardian for those children? Do you want a living will? It is, what your desires with respect to medical care. That's what we're referring to when we're talking about a living will, as opposed to a last will and testament, something very different. Um, a living will is usually a part in Maryland of the advanced medical directive or advanced directive. And it asks for your preferences of care in certain end of life or near end of life situations. Um, and also, how do you want your personal property distributed? And on this question, a lot of people, they say, well, I just want to give all of this to this person. But and it's not until they actually sit down and actually have to put their thoughts on paper, if you will, even if it's a virtual document, that certain things come to mind. Like, for example, maybe you have um, something you inherited, some jewelry that you inherited from a relative, maybe pearls or jewelry or something, or perhaps it's a piece of furniture that has been in your family for several generations. Um, Who do you want that to go to? I have a number of clients who are members of sororities and fraternities. And over the years, they have accumulated a lot of um, memorabilia that is very special. It's very important. And they need to decide, you just don't pack up those things and give them, to give them to charity. They have a particular special and rightfully so significance. Um, so you need to think about what's going to happen to those items. As I mentioned, in the fraternity and sorority example, do they are they donated to, back to the chapter that you belong to? Do you give those items to perhaps someone, a younger member of your family who would certainly appreciate those items? So again, this whole questionnaire answering process, it's supposed to trigger, it's supposed to jar that thought process and to help you get more organized. Um, and I will say this: even though the questions in the questionnaire that we ask sometimes are hard, sometimes are uncomfortable to answer, it's important that your overall goals and desires are written out so that your interests can be properly protected. Now, once you have submitted your answers, you are as thorough as possible. That gives us, as estate planning attorneys, the overall picture of your situation, and it gives us the right context, setting us up for the meeting, the consultation that's to follow. So, fast forward, the date of the consultation arrives. What happens then? Now we're going to talk about what happens during the consultation. Now, everything discussed in the consultation is confidential. That means that the attorney is forbidden, with very few exceptions, from discussing anything you talk about during that call or during that meeting. That's important for you to understand because estate planning is very personal. It's not just about money. It's not just about stuff. It's about people, right? And people and families can be complicated. So the more open, the more transparent you can be about your family dynamics, the better an estate planning attorney can design a strategy to help you meet your specific goals. And so we'll ask you, usually at the front end, we do a lot of listening. So we're going to ask you, what are your goals? What are your estate planning goals? And two, from my personal experience, two of the common answers I hear are one, that people want to provide for their loved ones, and two, they want to plan for possible incapacity. Now, with respect to providing for loved ones, we all have preferences. These preferences include our feelings as to who should or should not get certain assets once we die. Now, without advanced planning, state law is going to dictate who gets what and when. That's called dying intestate. Those of you who follow me should be very familiar with that term, dying intestate, and that is not where you want to be. As I said, the state, your particular state will have, an outline of who gets what and where, and when rather, and that one size fits all plan is chances are it's not going to line up with your personal preferences. This is especially true when there are former spouses, there are children from another marriage, when there are minor children, when there are estranged children. right? Or, just particularly larger families. Estate planning can help ensure that your wishes are carried out. And that can include making arrangements for spouses and children, ensuring that, assets are distributed in a way that is sufficient to provide for their ongoing support if that's what you want. And it can include specific transfers. It may be something as simple as making sure that personal items, personal effects, such as a family Bible or certain heirlooms, are transferred to those who are going to appreciate them. It can also include transferring real estate holdings um, or business interests to those who are able to properly manage them. All right. So that's as to, again, dealing with the concerns of providing for loved ones. I mentioned that one of the other goals that people commonly express is, planning for incapacity, because quite frankly, it can happen to all of us, to any of us. Mental health is something that many people take for granted, and we assume that we are always going to enjoy the full use of our mental capacities. But the research, unfortunately, paints a very different picture. There are some reports that show that 1 in 10 individuals over 65 are diagnosed with dementia, and this number increases as we age, right? So, planning for incapacity is to uh, structure your affairs so that your resources and your personal affairs are ready, are in place, or you have someone uh, designated to manage those things if in fact you become incapacitated. Um, there are several estate planning techniques that we use in order to assist you with this. Those techniques help to make sure that the financial resources are going to be available for you if and when the need arises. They can also ensure that financial resources are not wasted and do not disqualify you for, say, Medicare, if that's appropriate in your situation, and other federal benefits. Um, these estate planning techniques can include, advanced instructions. They can name third parties to carry out our wishes should you become unable to make your own decisions. And they can cover everything from financial decisions to what healthcare decisions you want made over your person, right? So that's the first thing. We ask you what goals you have. Another question that typically comes up during a consultation is, have you done any prior estate planning? Now, this might be asked on the form or discussed during the consultation, but that's important to know too. Um, you know, do you have an old will? I've had clients that I've assisted that have, wills that are like, 10, 15 years old. And they just haven't laid eyes on them for all these years. And so much, as you can imagine, can change over the course of 15 years. Beneficiaries die, who you want to leave certain items to can change because your feelings change, relationships change, and we'll talk about that in a second. But um, you know, finding out if you have any current estate planning documents in place is important. Um, by the way, the vast majority of people that reach out to our firm do not. Just an FYI. Another question we'll ask is, are there changes in, excuse me, in the size of your estate? So what we mean here is, have you acquired new properties? Have you inherited money or assets? Um, Another question is, are there changes within your family? Have you adopted adopted a child, for example? Um, have you, as a result of a remarriage, are there new children now in your familial circle? Um, Another question is, do you have a business? Now a bit what you'll need to consider, a business succession plan, and that's just a fancy way of saying estate planning for your business. So there's estate planning for your personal affairs, and then there's estate planning for your business. What do you want to happen to it? Do you want to sell it? Do you want to leave it in the family and assign individuals, groom them in order to take over the business? All that's part of business succession. So for potential clients who have a business, that's something that's discussed, and at least we're starting the discussion if they haven't considered it already. One of the other things we talk about is your excuse me, your beneficiary designations. And just to review, what's a beneficiary? A beneficiary is a person or entity that's going to receive the proceeds of your accounts upon your death, right? And it's always good to name both a primary beneficiary and a contingent beneficiary. So that way, if the primary beneficiary were to die before you do, the contingent beneficiary would inherit in their place. So beneficiary designations should play an essential role in your estate plan. They're pretty powerful. You can specify who should inherit, say, your retirement and life insurance assets without making adjustments to your will or a trust. Now, let me put a little thumbtack there. The importance of working with an estate planning attorney is to ensure that there is harmony, and that there's synchronicity between your life insurance or other beneficiary designations and your estate planning documents. You shouldn't be in a situation where there's dissonance, where there's conflict between the two, because that's not really a healthy estate plan, and leads to a lot of confusion. So that's yet another reason why working with an estate planning attorney who can look at your entire picture is going to make sure that your interests are protected. Now, we've talked about beneficiaries in prior YouTube videos, and possibly even Women Winning Wednesdays episodes. But while we're on the subject of beneficiaries, here are I'll give you 4 reasons why it's important to make sure that your beneficiaries are up to date. Number 1 is simply that your relationships are going to change over time. Feelings change. And while you may, 15 years ago, you may wanted to leave, $1 million life insurance policy proceeds to, one child, and one child alone. If your relationship with that child has deteriorated, that's something that you may want to consider, and clients often do, and that's normal, right? The second reason to keep your beneficiaries updated is if you get married. Now, if you marry, you are going to, at a minimum, need to look at any existing insurance policies, financial accounts, to see if you want to make any adjustments to those beneficiary designations. You want to add that new spouse as you deem appropriate. Um, Third reason is divorce. Let's say that you've divorced, and remarried. Now you've got and if you've got children with the new partner, um period, if you've never updated your beneficiary designations on, say, like a life insurance policy, during marriage number 1, your ex-spouse is the one that's going to inherit once you die, and that leaves nothing for your current spouse or any of your children. Nothing, right? So that's really important. And the last reason, among many, to keep your beneficiaries up to date is, deceased beneficiaries. If someone that you named a beneficiary dies before you do, that's a cause to update your beneficiary designations. If you don't, and you don't designate someone new, it can really cause complications down the line, and it may require your family to go to court, probate court, to straighten that situation out. So you really don't want to put your family or your estate in that situation. Again, we're sticking with what are we talking about during this consultation, during this conversation. And that's how I want you to look at it. It is a conversation. It is not only you sharing with the attorney, but the attorney is also talking to you, probing you, asking you questions. So view it as a conversation. One of the things we're going to talk about is, or the attorney will ask you, is who do you want to fill certain roles in your estate plan? So if you have a pretty simple, straightforward estate, and you decide just to say, you need just a wills based plan, you're going to want to know, you're going to have to decide whether, who will be in charge of taking care of your affairs. That's the personal representative. Excuse me. In some cases, it's known as an executor. If you have minor children, have you considered who you'd like to be a guardian for them if you became incapacitated, or if you died? All right. Then there's the agent, the role of agent. And you can have an agent in a financial power of attorney, as well as an advance directive, also known as a medical power of attorney. The agent is someone that has the authority to manage your financial affairs, even when you're still alive, and if you're unable or unwilling to act. They can pay your bills, they file your taxes, and manage your property. Your medical power of attorney makes medical decisions for you if you cannot make these decisions for yourself, right? Then we start, if it hasn't gotten personal enough for you already, we then go deeper, right? Or we should, into specific concerns, whether you have specific concerns about certain heirs. Now, a growing concern among people creating or updating estate plans involves adult children who have substance abuse problems, or perhaps mental health issues. But let's focus on substance abuse for a second. Substance abuse disorder and addiction, those issues can't be ignored when it comes to estate planning. And some parents, this is a no judgment zone. So some parents choose to disinherit children who have a history of substance abuse. These parents have, I believe, as I've been told, that they've spent enough on the child who has a history of drug and alcohol abuse. And they say, you know what, they're an adult, let them lead their own life. Individuals that create an estate plan and choose to disinherit a child are advised to, name that specifically, indicate that specifically in their estate plan, so that no one, afterward is saying, oh, well, that was a mistake, or they were left out by mistake. Um, if a client chooses not to disinherit a child in this situation with a substance abuse disorder, the best alternative is usually to create a trust with certain guidelines, right? And there are definitely many options for clients with a child or a potential beneficiary with a substance abuse or drug or alcohol dependency problem. Um, and as I said, trust, or different kinds of trust, are used to help you navigate that issue. Um, One of the other questions, which I'm not sure how many estate planning attorneys explore with you during the consultation, but they should, is whether you've considered charitable giving to organizations, schools, and religious institutions. This is something that is not usually on people's radar during the estate planning process. You can be so focused on your immediate family or circle that you lose sight of other ways in which you can create a lasting legacy. And the job of the estate planning attorney is to present you options that you may not have considered. And then lastly, we ask, hey, are there any questions that we have not answered for you? Right? Yes, if there are any lingering questions that you have towards the end of the consultation, that's the time to ask them before moving forward. Remember, you don't have to be an expert in estate planning in order to get an estate plan done, right? As the professional, the attorney's job is to clear up anything that you don't understand and guide you step by step through the process, right? So I hope that it has given you more information, more clarity on not only the intake process, as well as what you can and should expect from the estate planning consultation. Um, I want to just share some final thoughts. Our firm has currently an October promotion. We are offering 10% off of uh, consults for individuals, 30% off for couples when the consultation is booked at the same time. October is National Estate Planning Awareness Month. This is the month to get your estate plan in order, to get your affairs in order. We're in the final few months of 2022. And what a great way to end the year by checking this off your to-do list, knowing that you are going to be entering the new year with a greater sense of security and peace of mind is something that is the best gift that you could give to yourself. Um, I want to thank, I know we're a little bit over time, but there was a lot of important stuff here that I wanted to get to you today. But I want to thank each of you for tuning in to another episode of Women Winning Wednesdays. Again, it's great to be back with all of you. Go to my YouTube channel, check out the videos that we have there, that Fall Health and Wealth series. Make sure you check that out. Thanks for tuning in, and I will see you on the next episode of Women Winning Wednesdays. Take care, everybody.